I'm Matt Ellis. On this edition of Ask Our Experts from Mainstay Supportive Housing, we look at the topic of special needs trusts. Our expert today is family law attorney Harry Margolis of the Boston law firm Margolis Bloom D'Agostino. Hi, Harry. Thanks for being with us.
Thank you for including me, Matt.
About special needs trusts, please tell us why it's important for families with disabled children to establish a special needs trust.
It's basically a way to set aside money for a child with special needs so that we manage well and so the child can still qualify for any public benefits they may need now or in the future.
Can you explain the different kinds of trusts that families should consider?
Yeah, there are really three different kinds of trusts. So there's a trust that the parents or potentially grandparents would set up for the child as part of their estate plan. And usually it's not funded until they pass away. And that's often referred to as a third-party special needs trust because it's with the funds of the parent or grandparent for the benefit of someone else, the child, the third party. So that's number one. Number two, sometimes the child himself may come into money. They may be injured. The disability may be a result of an injury, and so they may have a personal injury award, or they may inherit money which hadn't been planned for, or they may become disabled after they've earned some money. In those cases, it's somewhat more restrictive what the trust can be. It's called a first-party trust because it's the beneficiary's own money. And there's special rules for those trusts, and the rules are in a statute that's often referred to, or in terms of the name of the trust, are often called a D4A trust, which refers to the Medicaid statute that authorizes these trusts. And then the third kind of trust is a pooled disability trust. It's actually authorized under another part of the Medicaid statute. And these are a whole number of trusts that are operated by a nonprofit association. And in Massachusetts, the principal one is called the Plan of Massachusetts.
What can a special needs trust be used for?
It can be used for just about anything. So the trust itself is usually not restrictive in how it can be used. It's totally discretionary. Where the restrictions come in sometimes has to do with the public benefits programs that the child or beneficiary may qualify for. So for instance, under the Mass Health's Medicaid program, there's some limits on income and assets. More restrictive is supplemental security income, where if an individual who's a beneficiary has money coming in, they lose their benefit dollar for dollar. So the trust can't give them money, but they can still spend money on their behalf. So that's the major restriction.
Are there qualifications necessary to be a beneficiary of a special needs trust?
So again, it depends on the type of trust. So for the third-party trust, someone setting it up for someone else, there's no restriction. So anybody can actually qualify. There, of course, it's whether someone has special needs or disabled is not always a bright line. So you don't have to meet any qualification. But that's less true for some other trusts. So for the D4A trust, again, you have to be disabled under the definition that's used for determining disability, either for SSI or for Social Security disability income. So for that to take advantage of that trust, you have to be able to show that you have a disability. Usually you do by already receiving this benefit.
What is the right time for families to begin setting up a special needs trust?
So if you know that you have a child or grandchild with special needs, and when you're doing your estate planning, that's when you should do it. So planning ahead is always better. But if people don't, you always do have the alternative of the self-settled trust. So it could also be done when someone does come into money. But again, that trust is a little more restrictive, and it can be more difficult because if the person themselves who comes into money doesn't have the legal capacity to create estate planning documents, you might have to go to court to get it done. So it's really better to do it ahead of time.
Harry, thank you very much. If people want more information, you can call 617-789-4500 or info@mainstayliving.org. Thank you to Attorney Harry Margolis.
Thank you, Matt.